Today we are going to be looking at the investigative process, which is a key element of criminal law. So to start, an arrest takes place when a person suspected of a crime is taken into custody. This is considered to be a seizure under the Fourth Amendment. Now, a person can be taken into custody in one of two ways. They can be taken into custody with an arrest warrant that is issued by a judge or a magistrate, or without a warrant if there is probable cause, meaning that there is a reasonable belief that a crime has been committed by an individual. An arrest warrant is a court order commanding that the person named in it be taken into custody. So in order to get a warrant, you need to file a complaint before a judge, and the person filing the complaint must describe and swear to the truth and circumstances of the alleged crime. Typically, this is a law enforcement agent of some kind. Based upon this information, the judge decides whether or not to issue the arrest warrant. So probable cause, once again, means having a reasonable belief that a specific person has committed a crime. It's based upon much less evidence than what is needed to convict somebody at trial. So at trial in a criminal case, you need proof beyond a reasonable doubt. When you are arresting someone, you really only need a reasonable belief, so that burden is much lower. There is not an exact formula for determining probable cause, so there is a little bit of leeway there. Police are expected to use their best judgment. Of course, an arrest requires far more than a suspicion or a hunch. Some sort of facts need to be presented to indicate that the person to be arrested has committed some sort of crime. Police do not need probable cause to stop and question an individual on the street. However, they do need to have reasonable suspicion that a person is involved in criminal activity. It is based on much less evidence than probable cause would mandate. But once again, it is more than just a hunch. If some of these things seem pretty vague, that is because they are. They are written to be rather vague. If a police officer has a reasonable suspicion that someone is armed and dangerous, they are permitted to do a limited pat-down of the person's outer clothing. And this process is called stop and frisk. It is something that has been the subject of a lot of media attention, really for a very long time, but also quite recently. If a police officer does not have probable cause or a reasonable suspicion, they may still approach any individual and ask to speak to him or her. However, the individual is permitted to decline to speak to police, and the police cannot view this as probable cause or reasonable suspicion that a person has committed a crime. Simply put, the police can ask you a few questions. You can say, no thanks, and the police cannot hold that against you. The most common type of arrest occurs when a police officer stops an individual while driving a motor vehicle. Now that person, and this sounds strange, is technically under arrest because they are not free to leave until the officer releases him or her. This is a detention, and it typically lasts as long as it takes the police officer to check identification and registration. The U.S. Supreme Court has ruled that police have the power to order all passengers out of a car when making a traffic stop. Talking about deadly force. A police officer may only use as much force as is reasonably necessary to make an arrest. The Supreme Court, once again, has ruled that deadly force may not be used unless it is necessary to prevent escape, and the officer has probable cause to believe that the suspect poses a significant threat of death or serious harm to the officer or others. In addition to the threat of criminal charges, a police officer who uses excessive force can be sued under the Civil Rights Act. So there are punishments for those who use excessive force, both in a criminal sense and in a civil sense. Search and seizure. The Fourth Amendment does not give citizens an absolute right to privacy, nor does it prohibit all searches. Reasonable searches are absolutely permitted. There is a phrase that is the reasonable expectation of privacy. An example of this would be, the Supreme Court has ruled that one does not have a reasonable expectation of privacy for trash left in a plastic bag outside of one's home while it is awaiting pickup. You have technically surrendered that garbage. So police are legally able to search a person's garbage if it is found outside the home. So not talking about going to the backyard and finding a trash can and searching it there. Once it's taken out for the trash collectors, then police are able to search it without obtaining a warrant. If a person is charged with a crime and the evidence brought against them was obtained unlawfully, that evidence is not permissible in a court of law. This is known as the exclusionary rule. And it states that while a person can still be tried and convicted, the unlawfully obtained evidence cannot be used at trial. So if there was an unlawful search and seizure, that evidence cannot be used at trial. The person can still proceed with the trial, but that evidence cannot be used. So, a little bit more about warrants. In order to receive a search warrant, which is technically a court order, a police officer must file an affidavit to the court. And an affidavit is a sworn statement of facts and circumstances. This warrant must specifically describe the person or place to be searched, so it can't just say, I want to search so-and-so's house, as well as the particular items to be seized. So it is not just a blank check to be able to search whatever you want. When the police conducting a search using a warrant, they are not permitted to conduct a general search of everything in the specified place. They are permitted to seize evidence related to the case or any other illegal items if they are in plain view during the search. Searches without a warrant. Searches of private homes generally require a warrant. However, there are some circumstances in which a search can be conducted without a warrant. One of these is search incident to a lawful arrest. So police are permitted to search a lawfully arrested individual and the area immediately around that person for any sort of hidden weapons or evidence that could possibly be destroyed. This is known as a grab area search, essentially meaning just the general area around a person during the time of an arrest. If the arrest occurs in a car, the police are permitted to search the passenger seats of the car, but not the trunk, because the person being arrested would technically have access to the other parts of the car, but would not have that easy access to the trunk. Thus, police are not able to search it. Stop and frisk. Police officers who reasonably think that a person is behaving suspiciously and is likely to be armed may stop and frisk the suspect for weapons. The Supreme Court has also stated that the police are able to seize illegal substances, such as drugs, during the frisk if, and this is really clearly laid out, if the officer's sense of touch makes it immediately clear that the object felt is an illegal one. So if, while somebody is searching it, they feel something and they can immediately recognize it as something that is illegal, then it is a lawful search and they can seize it. This is known as a plain feel exception. So if something can be plainly felt as a weapon or some sort of drug, that would be an example. Other types of search for that warrant. Consent. Police are able to conduct searches with permission. Makes sense. If searching the property of a married couple, the police may not conduct a search if one of the two married parties objects to the search. If an unmarried couple were living together, then police could search with the consent of just one of the parties. If it is a married couple, they need the consent of both parties. Other types of searches without warrants, border and airport searches. So customs officers are authorized to search without warrants and without probable cause. Same goes for TSA. Vehicle searches. A police officer with probable cause to believe that a vehicle contains contraband may conduct a search of the entire vehicle without a warrant. Once again, you need probable cause for that. Plain view. If an object connected to a crime is in plain view and can be seen from a place where the officer has a right to be, it can be seized without a warrant. Hot pursuit. Police in hot pursuit of a suspect are not required to obtain a search warrant before entering a building that they have seen the suspect enter. They are also able to seize evidence found in plain view during the pursuit of the suspect. Basically, someone flees from the police, they're running, they enter some sort of building, even if it is their own home. If the police are able to follow that suspect into wherever they enter, they are legally allowed to be there, and they can legally seize any evidence that's in plain view. And emergency situations. Police are not required to have a warrant during some emergency situations. For example, searching a building after a bomb threat would be an example, or entering a building after smelling smoke or hearing some sort of scream would be permitted. Something that would indicate that people are in some sort of immediate peril. Suspicionless searches. So some searches have been upheld by the courts regardless of whether or not there was reasonable suspicion. So there are a few examples. Searches at or near borders, searching for illegal immigrants. Other types. Highway sobriety checkpoints. So DUI checkpoints are an example of suspicionless searches that have been upheld by the courts. Mandatory drug and alcohol tests for railroad and airline employees who have been involved in accidents. So this is another example of suspicionless searches. Excuse me. Racial profiling is not permitted as the sole reason for an officer to stop an individual. However, there are circumstances in which race can be grounds for a stop. Once again, it cannot be the sole reason for some sort of search. An example of this is the fact that police can use race as a determining factor for stopping someone if that person fits the racial description of a suspect and is seen fleeing from the scene of a crime. Makes sense. If you were to say that there was a bank robbery on Market Street and it was a 5'9" white male and I happened to be walking down Market Street, they could stop me because I would fit the description of that suspect. So race cannot be used as the only reason to stop someone, but if somebody fits the description of a suspect, then it can be used. Interrogations and confessions. It is commonplace for police to complete an interrogation of a person accused of a crime. Sometimes these questionings lead to confessions or admissions of guilt. Sometimes they don't. The Fifth Amendment of the U.S. Constitution protects individuals from self-incrimination, meaning that individuals do not need to produce information that would implicate them in some sort of crime, nor do they need to testify at their own trial. A defendant the jury cannot hold it against the defendant if they do not testify at their own trial. It is not required by law. Now, in order for confessions to be admissible in court, they must be voluntary and they must be trustworthy, so they cannot be coerced. The use of physical force, torture, threats, or any other extreme interrogation techniques make a confession invalid. They invalidate the confession. It cannot be used. Individuals are required to be read their rights as they are arrested. These rights are referred to as the Miranda rights. The reason why they are called the Miranda rights is because they are named after a Supreme Court case, Miranda v. Arizona. So Miranda versus Arizona in 1966. These are you have the right to remain silent, you have the right to an attorney, all of those that you hear read in every single police show ever made. The next slide is just a recap of the sequence of events in the criminal justice process. If you have any questions, feel free to drop by office hours, which are 8 to 10 or 1 to 3. And you can access that via the link on the bulletin board on campus. You can also email me or on campus message me. Have a wonderful Monday. I'll talk to you tomorrow.